First, though, was the federal government right to invoke emergency powers when truckers blockaded bridges and roads? A public inquiry launched today will try to determine if it was necessary. The government was legally required to hold an inquiry after using the never-before-used Emergencies Act last winter. Marco Mendicino is the Minister of Public Safety overseeing this file. He joins us now. Hi, Minister. Good to see you. Thanks for making the time.
Hi, Vashi.
If the judge or justice heading this inquiry asks for documents that require cabinet confidence to be waived, Minister, will your government waive it?
Well, I understand why you're asking the question, but I think it would be the height of preempting and usurping the independent process, which Judge Rouleau was just charged with launching today. One of the reasons why we chose to pursue a full-blown public inquiry under the Act and through this order in council was to foster more independence, more transparency, more accountability. The judge will have the power to compel witnesses, information, and documents, including some classified information. So our intent is to cooperate with this inquiry so that he can have a fulsome record to examine the circumstances under the Act, and also to perhaps propose some recommendations based on lessons learned.
I'm not sure why you're characterizing the question of whether you'd waive cabinet confidence as usurping anything that you just pointed out. I'm not asking whether or not you're going to tell the justice what to do. I'm just asking you, if he asks your government to waive that confidence, to supply documents that require the waiving of cabinet confidence, will you do it?
Because it presupposes that exactly what documents he's going to ask for, what information he's going to ask for. Look, Vashi, as I say, I understand the curiosity and the anticipation behind exactly what procedural steps will be taken, including what information will be put forward to the judge. But again, we have to respect the independence of this process, which has just begun today. And the spirit with which we launched this program was to give as much latitude and independence and transparency so that there can be accountability with the circumstances that led to the invocation of this act. I would point out that, again, going back to January and February, that the impacts of the illegal blockades and the occupation were devastating to our economy. It idled jobs, saw businesses shut, including here in the nation's capital. The Trudeau Center was shut. We saw our most robust trade corridor shut down for nearly a week in Windsor at the Ambassador Bridge. And we only invoked after we got nonpartisan professional advice from law enforcement who said universally that they could not use existing tools effectively to restore public order. Once we invoked it, we made a commitment for it to be very time limited, very targeted, and then we revoked it as soon as we could to restore public safety. This process will examine that and hopefully put forward some recommendations on the go forward.
And I understand, Minister, that your government feels the use of the Act, the invocation of it, was justified. All I'm asking is, will you supply every piece of information necessary to the justice in order to underscore that point? I'm not asking you to limit the purview of the justice or presuppose what he might ask for. You didn't answer the question in your press conference earlier, so I'm just asking to you straight up now, and you're not answering this time either. Why are you hesitant to say the government will waive all cabinet confidence, should it be, and I'm not presupposing that it will be, but should it be necessary?
Well, I think first it's important to remember what the cabinet conferences are designed to protect, which is to allow for a robust debate and an exchange of ideas around sensitive decisions. And as you pointed out, this was the first time that the Emergencies Act was invoked. So it is a hallmark and a constitutional principle within our democracy that we have this space. And as to how that principle will be applied, it is very much dependent on the factual circumstances and around the documents and around the information that the judge may wish to look behind. I don't want to usurp that process because it's an independent one. And I'm saying we'll cross that bridge when we come to it.
I understand what you're saying. I guess the reason that I'm asking is because I listened very closely to the criticisms, as I'm sure you did, of your government, and not just from people who were maybe upset about its application, but who were genuinely worried that the bar was not met for invoking it, that it is an example of government overreach. So the reason I ask, will you just put it all on the table, is because how else will you allay their concerns? If everything is protected by cabinet confidence, if there were major disagreements in cabinet, if there was pushback to the idea of using it, if there are facts that you can put out there through cabinet documents, why wouldn't you?
Well, first of all, we've been very forthright all along in the circumstances that led to the invocation of the Act, including publishing an extensive backgrounder, which, among other things, laid the factual basis for the invocation of the Act. There were days of debate in the Emergencies Act. I mean, to the credit of the drafters, what they contemplated is that whenever the Act would be invoked, that there would be a number of review processes. One is the Joint Parliamentary Committee, which has already begun its work. And the second is the inquiry. And I would just point out that, again, one of the reasons why we chose a full-scale public inquiry was to promote greater transparency, greater insights into how this decision was taken. And I think, to bring this answer full circle to the nub of the question, which you've posed a number of times, and I understand why, is that we will take it step by step, consistent with the independence and the integrity of this public inquiry, which was launched today.
Respectfully, wasn't it required that you launch the inquiry? I mean, you're positioning it as though you selected this. I mean, you had to by invoking the Act.
Well, there were different ways in which we could have done it. We could have done an internal inquiry. We chose to go the full route of appointing a commissioner with the full powers to compel witnesses, to compel documents, to compel information, including classified information, so that he has the information that he needs to conduct a robust examination and review. And as I said today, Vashi, I mean, this is not just a check in the box for us. We are embracing and inviting this exercise because we are confident that it was the right call, but we also want to respect what the law requires. And we also want to invite, again, a very thorough, independent examination, not only so that we can feel validated in the invocation of this Act, but equally to be sure that we take some lessons away, that we have some recommendations on the go forward around how law enforcement responds so that this kind of thing never happens again.
And I do want to ask you about the recommendations in a second. I just want to be clear to our viewers, though. I understand your point about it not being a check in the box, but you are saying it will be a case-by-case basis through which you decide whether or not to waive cabinet confidence. The order in council for the inquiry also states that the commissioner has to take, quote, all steps necessary to prevent any disclosure of information to persons or bodies other than the government of Canada that would be injurious to international relations, national defense, or national security. Who will decide what is injurious?
Well, and for good reason, because obviously to disclose information into the public domain, which could be injurious to either national security or international relations, would be completely counter both to the principles that I've already referred to, as well as keeping Canadians safe. So that is an important principle. It's one not to gloss over, and it's one that can be reconciled with the independence of the process which was launched today by the judge. And again, if we cross those moments and those bridges when we come to them, obviously have full faith in the judge to balance those competing values, which are all part of the independent examination.
Respectfully, Minister, my question was who will determine what is injurious?
Well, as I just said, Vashi, we're placing faith in the judge to make those determinations in conjunction with the dialogue that will occur with the government should we come to those decision points.
Okay, sorry. In layman's terms, pardon me, I'm just not clear. Does that mean that the government will be saying, no, this is injurious to national defense, to national security, that's why we can't supply it, or you can't make this part of the inquiry public? Or will the judge by himself be saying, no, I think this is injurious, I can't make it public? And again, I'm just asking to really ascertain, and I understand that you're a lawyer and I'm not, but I'm trying to ascertain on the behalf of many Canadians who aren't lawyers exactly what information they will be privy to.
No, I mean, it's an entirely fair question. And as I've tried to articulate in straightforward language, these decision points will be taken by the judge if and when it's necessary for him, in his judgment, to look at information which may be covered by privilege. I'm going to some pains to say I don't want to preempt that process so as to respect the independence of it. And again, that is something that is very important in the fullness of the review and the time that will be invested in it. And it's an important exercise. We have faith in Justice Rouleau, who's an experienced judge, both in trial courts as well as the Court of Appeal, to both be knowledgeable about those principles, which have to be reconciled with his work to look into the motivations of the hardened core that were trying to agitate these illegal blockades, which we're very concerned about, to take a look at perhaps how some of the funding infiltrated into that movement to further exacerbate the conditions which saw the integrity of our borders, our economy grind to a halt, public safety at borders, in our community here in the nation's capital, completely laid to siege. This was an extremely difficult moment in time. We took this decision thoughtfully, carefully, deliberately. We invoked and then we revoked as quickly as we could. This part of the exercise, we're confident, will be taken with the same care and attention. Not only we hope to validate the decision, but equally, again, to take some lessons and some recommendations going forward.
Okay, Minister, I'm out of time. I'll leave it there. Thank you very much for your time.
Thank you, Vashi.
Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.